Oscar Pistorius has been denied parole. The Department of Correctional Services says Pistorius did not complete the minimum detention period as ruled by the Supreme Court of Appeal. Pistorius is serving a 13-year sentence for the 2014 murder of his then-partner, Reeva Steenkamp. Let's get reaction from attorney Ulrich Roux. Thank you so much, Ulrich, for speaking to us on eNCA, as always. Now, we know that an inmate has to serve a minimum detention period before being considered eligible for parole. We understand there's some confusion about exactly when the sentence started because of those dual sentences, but surely the Department of Correctional Services should know that in order to make a determination of eligibility before such a hearing is even considered. Ulrich, unfortunately, you are still on mute. Could I ask you to unmute yourself? Let's try that again.
Is that better?
Perfect. Thank you so much.
Yes, thank you for having me. Certainly an unexpected turn of events today with the Parole Board confirming that they had received a letter from the Supreme Court of Appeal which confirms that Pistorius would only be eligible to bring an application for his release on parole in August 2024. Now, the Department of Correctional Services received this letter on 28 March already, 3 days ago. So it is quite bizarre that the parole hearing indeed proceeded today, given the fact that he has not even met the most important minimum requirement to be eligible for parole, and that is serving out half of your sentence. Now, the confusion comes in the fact that he has been sentenced 3 times in this matter. But the sentence that is of importance is the final sentence handed down by the Supreme Court of Appeal, which confirmed that he was convicted of murder and that he should serve a minimum period of imprisonment of 15 years, but then also taking into account the time that he had already served, which was 1 year and 7 months, hence the sentence of 13 years and 5 months. And what they have now brought clarity on in the letter from the SCA is that half of 13 years and 5 months must be served, but only from November 2017, when that sentence was handed down. So it's certainly quite a complex calculation that needs to be done, but the SCA providing clarity today and saying he is not eligible for parole yet, and that he should bring his application in August 2024 only.
So parole consideration, according to my understanding, is triggered automatically. So do we then understand that these concurrent sentences and the date from which that 50% minimum is to be served has then somehow been inaccurately captured somewhere in that automatic system?
Yes, it was indeed. It was a fault made and a mistake made in the calculation of the term that he needs to serve. It is not an automatic right to parole. The person who brings an application to be released on parole must bring an application to the Parole Board. So it's not a question of you automatically get called up. It's just that minimum requirement must be met, and that is that half of your sentence must be served before you can even be taken into consideration to be released on parole. Now, the most important factors which the Parole Board needs to consider is whether the person has in fact been rehabilitated during his or her period of incarceration, whether they still pose a risk to the safety of society should they be released on parole. And then the interest of justice and the interest of society plays a big role in that the victims of the crime, in this instance, Reeva Steenkamp's parents, Barry and June Steenkamp, they must also be considered, and their views must also be considered when deciding if a person should be released on parole or not. They came out today placing on record that they are opposed to his release, confirming that he, in fact, does not show remorse, he does not accept responsibility, and that he purely reached out to them because he knew that that would be a consideration to be taken into account by the Parole Board. So, yeah, certainly I think a big setback for Pistorius. One would now have to wait and see if he does take any further steps. He would be entitled to approach the Supreme Court of Appeal should he feel that they miscalculated this period. Alternatively, approach the Constitutional Court directly in order to state his case and say why he believes that he's already served half of his sentence. But we'll have to wait and see what the next steps are that he's going to take.
So Pistorius' lawyer, Julian Knight, has already indicated after today's proceedings that they would be taking the decision on review. What does that process entail? And is it possible to speculate about the chances of success ahead of such a process being started?
Well, I can only imagine that he's referring to the Parole Review Board. Now, when an application for parole is dismissed by the Parole Board, then you have the option to take that decision on review, and you then approach the Parole Review Board in order to consider your application again. The difficulty here is that the Parole Board and the Parole Review Board are bound by the clarification that the Supreme Court of Appeal sent on the 28th of March. So there's not much that they can do about it. I think that they need to obtain clarity from the SCA, and if they differ from the SCA in terms of the calculation that has been done, then they must bring an application before the Supreme Court of Appeal in an attempt to rectify that. But the Parole Board and the Parole Review Board is not going to be of much assistance at this stage, in my opinion.
So looking at a separate case, Donovan Moodley is also up for parole, a marathon hearing held on Wednesday. And we know the circumstances differ significantly in that he's serving a life sentence for the murder and kidnapping of Lee Matthews. And ultimately, that the Minister of Justice must decide whether to grant parole in that instance. How does that process unfold?
Yes, if a person is sentenced to a period of life imprisonment, our Correctional Services Act confirms that the only person who is able to grant parole to such a convicted prisoner is the Minister of Justice and the Minister of Correctional Services. And that is only applicable to people who serve out a life sentence. So the person would then first go through the Parole Board, and then the Parole Board would make recommendations to the Minister, and the Minister then has the last say of whether this person does in fact qualify as a person to be released on parole. That is not the case with Pistorius, because he was not handed a period of life imprisonment. He was sentenced to 15 years effectively, which means that the Parole Board is the entity who will either grant him parole or not.
Well, thank you very much for giving us some clarity on this issue. I think a lot of people today following the news and confused by the denial of parole, which in essence is actually not parole being denied. He's simply not eligible at this stage. Thank you very much. Attorney Ulrich Roux giving us some clarity there on the decision today that Oscar Pistorius will remain behind bars until August 2024 and will only become eligible for parole then.